Hello, everybody. Good afternoon. Welcome to ACS's annual Supreme Court preview. There are some seats over here for anybody who's looking. I know we have a very full house today. For obvious reasons, there's a lot to talk about. ACS, as most of you, maybe all of you, I hope know, was founded in 2001 and is a national network of lawyers, law students, judges, and policymakers who believe that the law should be a force to improve the lives of all people. ACS works for positive change by shaping the debate on vitally important legal and constitutional issues such as the ones that we'll discuss here today. Now, as many of you may recall, in past years, I've stood before you in September and said, "Oh my goodness, what a blockbuster year we're going to have in the Supreme Court." Well, this year, not so much. With Justice Scalia's passing in February and the refusal of the Senate Republicans to consider the nomination of Judge Merrick Garland, the court is a diminished institution and has only had a limited ability to perform its constitutional role. And as we saw at the end of the last term, with only eight justices, the court was unable to resolve a number of critical cases, such as U.S. v. Texas, involving the nationwide injunction on the DAPA immigration program, and Zubik, the case which asked whether nonprofit religious employers can be required to provide employees access to insurance coverage for contraception. And that's not to say that there aren't or won't be important cases before the court this term. We know the court will again examine the constitutional contours of the death penalty and electoral redistricting, and of course, cases will be added to the docket. But just how many and on what topics does seem directly related to when the justices can expect to be joined by a ninth colleague. I can speak for many of us in saying that we hope we won't have to wait much longer. And just to put a fine point on the significance of the discussion we are going to have today, though, is to note that the next president, whoever he or she may be, is going to have a singular opportunity to fill not just the vacancy that Merrick Garland may take, but also perhaps several others. And that the court, as so composed, will be addressing issues that many of us consider some of our most significant constitutional questions, such as, can we regulate climate change? Can a corporation claim a religious belief to trump a woman's access to contraception? Can workers join together to form a union? And not only will there be these vacancies to fill, potentially, but there are obviously many, many more vacancies throughout the federal courts, and we're once again approaching a near historic record of current and future vacancies, and have right now 35 judicial emergencies. So there's a lot at stake in the court system in the next presidential administration, and there's a lot at stake with the Supreme Court. So let me turn this over to our very esteemed moderator, Garrett Epps, who's going to lead us through this important discussion today. Garrett, as many of you know, wears many, many hats. He is a former staff writer for the Washington Post. He's a professor of constitutional law at the University of Baltimore. He's a contributing writer to Atlantic Online and serves as that magazine's Supreme Court correspondent. Has a brilliant piece, I believe it was in Today. I know I read it today, so I think it was in today's Atlantic, that I would commend to all of you. And Garrett is also a contributing editor to the American Prospect. His most recent book is Justice 2014, 9 Clashing Visions on the Supreme Court. Garrett, how do you find time for all of that, as well as making time for us here at ACS, for which we are eternally grateful? So thank you again, and please, all of you, join me in welcoming Garrett.
Well, Caroline, thank you. I have to say that introduction is more generous than usual, given that we have a stellar panel here, and My job, I think, is basically to stay out of their way, except for being, the time capo, and I will do that. But I want to welcome everybody to a panel on a term that's really not going to be like any term most of us can remember, in a lot of very interesting and sobering ways. And I want to introduce this panel, and I want to direct everyone's attention to the full biographies that are available in the materials that were distributed to you when you arrived, because this is an incredibly accomplished group, and in the interest of time, I'm going to shortchange their bios. But as proceeding from my left, we have Carolyn Shapiro, who's the former Solicitor General of Illinois and the founder and co-director of the Illinois Institute of Technology, Chicago-Kent College of Law Institute on the Supreme Court of the United States, which sounds to me like holding seriatim, two of the coolest jobs in the world. To her left is Kristen Clark, President and Executive Director of the National Lawyers Committee for Civil Rights Under Law. To her left, Professor Nicholas Quinn Rosenkrantz teaches constitutional law and federal jurisdiction at the Georgetown Law Center. He is also Senior Fellow at the Cato Institute and a Director of the Federalist Society. And finally, as many of you know, Paul Smith, who is chair of the appellate and Supreme Court practice at Jenner and Block, and a veteran of 19 Supreme Court arguments, including Lawrence versus Texas and Brown versus Entertainment Merchants Association. So, there's some expertise to my left. And we're going to start by each panelist, I think, will just take 5 minutes or so. We want to keep this moving because we want to hear your reactions at the end. But the first question everybody wonders about, right, as Carolyn said, people don't come to you and say, what about that Blockbuster case? They come to you and they say, what the hell is happening? What's going to happen to the Supreme Court? So if I could get each person just to talk a little bit about, whither the court and what are the implications of its current situation. I have outsourced my timekeeping duties to this gentleman over here, so keep an eye on him. So Carolyn, why don't you start off?
Well, first of all, thank you very much, Garrett and Caroline, for having me here. I, of course, was going to start out by saying that it's not really a blockbuster term, but it's already been said. So I'll say a little bit about some of what obviously I think is going on is that there are only 8 justices. They're worried about not being able to decide cases, as we saw. Although I don't see in the petitions that are coming up, at least in the next couple conferences, anything that stands out to me as something that under normal circumstances I would be excited or terrified about them taking. So some of it just sort of has to do, I think, with what's teed up at any given moment. But I think that there's another reason, in addition to the diminished personnel, that is leading the court to keep a kind of low profile right now, which is the election. I think that most of the justices, and certainly the Chief Justice, really don't want to be an issue in the election and would like to sort of fly under the radar as much as possible until after November 9th. I think we'll get a better sense of whether or not I'm right about that soon when we see what they grant next week. The long conference is on Monday, so we should know by Tuesday or Wednesday at least some of the decisions that they've made about what to take. And while as I said, I don't see any petitions, although I certainly could have missed some. I haven't seen any that leap out at me. There are some themes in the petitions that could give us a hint about whether or not they're willing to raise their profile. There are a number of Brady-related claims, given the sort of the current focus on miscarriages of justice. I think that those types of cases could garner some extra attention. There are a whole host of cases involving the Federal Arbitration Act, and although that makes most people kind of roll their eyes, it's actually remarkably important, as I'm sure everybody in this room knows how important the Federal Arbitration Act is, to allowing or not allowing individuals to actually meaningfully pursue claims against employers and retailers and et cetera. So we may have a better sense by mid next week. And then in particular, we may know about, related to a couple cases I think we're going to talk about later. One is the Virginia case involving transgender student, which is actually listed, I believe, listed for Monday. And the petition for rehearing in the United States versus Texas, which we'll also talk about later. Depending on what, if they take any action on either of those cases, we'll have some sense. The last thing I'll say about the court in this election year is that I also think that the court, even if it tries very hard to hide, ultimately I don't think it's going to be able to do that. Inevitably, there's going to be litigation about things that are happening leading up to the election. Of course, there's already litigation about voting restrictions, about all kinds of things that are going on in the states. I read that just yesterday, appellate court told Texas that they have to change their voter education materials so that they are consistent with the court order about in terms of what voters actually have to do with respect to identification so that it's accurate, legally accurate. And that Texas has already said they're going to seek review. Whether they do so in an expedited manner or not, I don't know. But there will inevitably be some litigation that finds its way to the court between now and the election. And that's really, I think, going to cast the court in a very uncomfortable position where it will have not only the problem of being 4-4, but the problem of potentially appearing extremely partisan. And so with that, I will turn it over to Kristen.
So thank you to ACS for hosting this session today, incredibly timely on the heels of what will most certainly be a historic term and one that we will read about in the history books because we are officially in uncharted territory with 189 days now lapsing with the vacant seat on the court. I think that the second record holder is Justice Brandeis, a record set more than 100 years ago when there was fierce resistance to the nomination of Louis Brandeis. I think that the resistance that Brandeis faced was very different. I think that there was anti-Semitism. I think that there was a lot of resistance to Brandeis because of his views as somebody who was anti-big business and anti-big government. But certainly this era that we are in now is one that we will read about in the history books. I am deeply concerned about the integrity of the Supreme Court. I think that every day that continues to pass stands as a threat to the institution, the specialness of the institution. A court that stands at the helm of one of our branches of government, in my view, stands in a state of paralysis without that ninth and decisive vote in place. We're going to talk about some of the cases that are before the court this term, but there are life and death matters that are before the court, including an incredibly important case that we'll talk about in a moment concerning race and the death penalty. As a civil rights organization that's deeply embroiled in voting rights litigation across the country, this sadly has become part of our calculus. What do we do to resolve cases where time is of the essence? And when you're talking about having the ability to exercise the right to vote in an election, time most certainly is of the essence. What do we do to secure relief for aggrieved individuals where we know that we may not reach the finish line with the other side always having the option to go before this Supreme Court, which is almost like buying time, right? Because Texas, Carolyn mentioned the Texas case. We are litigating the Texas photo ID case, and the state has indicated that despite the Fifth Circuit's clear ruling finding the photo ID law in place in that state to be discriminatory, that as the case kind of goes back to the district court, which will now also look to see if the law has a discriminatory purpose, we know that Texas intends to take the outcome of this case to the Supreme Court. And what we know is that we face the risk of that 4-4 tie vote and no clear resolution. So I'm very concerned about this kind of uncharted territory that we are in.
Great, thank you. I'm delighted to be here. As Garrett mentioned, I'm on the board of directors of the Federalist Society, and so I bring you greetings from the Federalist Society. We,
So to speak.
your events look a lot like our events, and we like that. We consider imitation the sincerest form of flattery. So our Supreme Court preview panel, I think, is going to be in this very room a week from today. So I'm rehearsing here today. So I guess I'm invited here to strike a slightly different note from the other panelists, so I'll try to do that. I think it falls to me to say, yes, the court is greatly diminished by the loss of Justice Scalia, per se. So Justice Scalia was a giant in the law, of course, and brought textualism and originalism to the court and to mainstream jurisprudence. So that will be missed. But I think even beyond that, he's really like a larger-than-life figure at the court. His friendship across the aisle, as it were, with Justice Ginsburg was actually quite an important dynamic at the court, and so all that I'm sure that he will be missed at the court, and he is missed at the court, and I think it maybe falls to me to remind us of that. So the court does have 8 justices now. What I would say is, I certainly agree with everyone here that it's hugely important who populates the Supreme Court. And I was thinking about this recently, just to put a sort of fine point on it. The person who fills Justice Scalia's seat, if that person serves for as long as, for example, Justice Stevens, that person will be on the court deciding constitutional cases in the year 2050. It's just amazing to think about. I mean, we will have long forgotten Donald Trump. We will have long forgotten Hillary Clinton and the issues of this election. And yet that person will still be deciding cases. We may be living on Mars by then. But that person is going to be deciding cases in 2050. So it is hugely important, of course. Now, but I don't think I agree that the court is somehow a dramatically diminished institution because it has 8 justices for this moment. And just a bit of a reminder, the court has, often has 8 justices when a justice has to recuse themselves. There's been vacancies in the past, of course. But more to the point, consider the original Supreme Court had 6. So in the Judicial Act of 1789, they provided for a court with 6 justices. That is to say, the framers, first of all, thought 6 was plenty, and also thought that an even number would be fine. So, and the court has had, both fewer than 9 and also an even number at, a variety of points throughout its history. So, I'm not sure that the fact of 8 or the fact of a vacancy is itself somehow tragic or diminishing to the authority of the court. I think maybe the framers liked the idea that you would have to persuade someone from across the aisle, as it were. So if it were 3-3, the court would do nothing. The court had to be 4-2 in order to do anything. And so it's well established. And when there's an even number of justices, if there's a tie, it just means the lower court opinion stands, and that's oftentimes not so bad. So, and then just one other reminder, consider that in the 1980s, the court used to hear 150 cases a year. And now we're down to about 80 or 75. So there's certainly no legitimate concern that the workload is going to overwhelm these 8 justices. The 9 used to handle doubles. So I'd say, there's certainly the court is better with a full complement, and I hope that we will confirm justice in due time. But I think that the court can get by with 8, and I don't think this is some sort of dramatic blow to the court's prestige.
Hi. Let me start off with one point of agreement with Nick, just so we can start off that way. I do think that the the absence of Justice Scalia has changed the tone at the court, and that he is missed in the sense that he was such a larger-than-life figure. I argued a couple of cases after he passed away last spring, and it was very quiet in the courtroom almost. It wasn't that people weren't asking questions, but it just didn't feel the same without the ever-looming presence of Justice Scalia about to swoop in with his very funny and cutting questions that he could come up with. So I do think it does change the environment of the place. I certainly would disagree with the idea that we should just sort of go on and on with 8 justices and that that's no great harm. One of the things that you learn from last term, and we'll learn some more from the beginnings of this term, is having too many 4-4 divides ends up making the Supreme Court just not functioning very well. We saw a whole number of cases last term which were basically not decided, either because they found a way to agree on an opinion that says essentially nothing, and that was what happened in the Zubik case about religious exemptions from having to ask for an exemption for contraception coverage under the ACA. There's a very important case called Spokio about whether or not how the standing requirement applies to statutory violations in a kind of class action context. And they wrote a decision that both the plaintiff's bar and the defendant's bar think they won. So you sort of can tell how decisive that was. And we're going to see, plus we have, of course, had major 4-4 cases like the immigration case. And I think we're going to see more of that as long as we only have 8 justices, because the court it does struggle to find ways to coalesce around things, but it's just not easy for them. And they are much more decisive when they have 9 justices, and Justice Kennedy could decide which way to go, as it was in the past, or maybe it won't be him in the future. But at least you then have the law developing and clarity in terms of what the law is, which some of these cases just haven't given us. The other comment I would make before we get on to some specific cases is just contemplate the prospect of Hillary Clinton winning. I kind of go back and forth each day with the polls about whether I think that's going to happen or not going to happen, but today the polls were good, so I'm going to talk about her winning. The question I think a lot of progressives have is how quickly are they going to take down a lot of things that everybody dislikes about where the court's been in recent years. And I caution people that the court doesn't really work that way. They don't suddenly go from a 5-4 conservative majority, at least in some areas, to a 5-4 liberal majority, and suddenly everything gets overruled. The court doesn't like to overrule prior decisions. It particularly doesn't like to overrule prior decisions if it's going to be perceived as a result of one justice replacing another justice because a Democrat happened to win the White House. Because I think that's understood as a recipe to undercut the legitimacy of the court and make it seem like it's just another political institution. And so what the court tends to do instead is to sort of start narrowing prior decisions, undermining prior decisions. You've certainly seen that in the Roberts era in reverse, with lots of decisions which don't overrule things, but at least start off by narrowing them or undercutting them. And I would foresee that process in reverse. So those of you who think that Citizens United ought to be in the dustbin of history, and I'm not endorsing that view or not, but there are many people out there who think that, I think you're going to have a long wait, even if Hillary wins. The area where I think there are some areas where I think the court would get active more quickly. One is this area of voting burdens. There, I think, is a growing perception that the Crawford case and the whole deference to legislative creation of deliberate burdens on voting. I'm bitter about Crawford because I lost that case, but is something where the courts have a need to get more aggressive. And I actually think the other area that's sort of in parallel with that is some of these abortion burdens that have been enacted in the last few years. That we started to see that with the health regulations that were invalidated in the Texas case last year by a 5-3 vote. Some of the other kinds of things involving waiting periods and requiring people to have things read to them and all that sort of stuff. I would imagine the court would get fairly actively involved in that if there was a liberal majority. But it's going to take a long time for the law to evolve. That's just the way the Constitution evolves in this country, regardless of who wins the election.
Well, that kind of sets the stage, and we have a couple of minutes. I wondered if you guys wanted to talk back and forth. One of the things about the 4-4 court, I'll just throw this out there to see if anybody's interested. Paul was on a panel earlier this week. It's panel week. But, one of the points was made that the rise of state standing to challenge federal regulations. And we've got a new challenge that's just been filed to the overtime regulations by states saying this burdens our economy, is giving rise to the phenomenon of the nationwide injunction issued by one district judge. And when you have a 4-4 court, do we see this as a kind of a malign trend in which you end up with the Southern District of Texas controlling immigration policy and so forth? Has anybody got any thoughts about that? And if not, share some other thought.
Well, we've got a roadmap for that in the immigration case. You know,
Yes.
you find the judge. It was only one judge in the district or whatever it was. You get a split decision in the Fifth Circuit, and you're off to the races. And so that does seem to be the wave of the future, that the attorneys general. And I think, as they said in the panel on Monday at Georgetown, this wasn't really started with conservatives. It probably started in the environmental area with progressive attorneys general filing things like Massachusetts versus EPA. But it is definitely accelerating. And there's more constitutional law probably discussed at these Republican and Democratic attorney general meetings than anywhere else these days, because that's where the action is.
And I don't think that we should, I think it's important to underscore the impact of the 4-4 ruling from the Supreme Court in U.S. v. Texas. This is a case that would have implicated the rights of 5 million undocumented people who were seeking relief, seeking immigration relief. This is a ruling that disrupted a tremendous amount of work that happened at the federal level to figure out a way to fix what many deemed to be a broken immigration system. So as I reflect on the last term, it is the 4-4 ruling and failure to resolve the questions at issue in U.S. v. Texas that I think best illustrate how broken this Supreme Court is without that ninth and decisive vote.
I think I'll weigh in a little bit on the 4-4 issue as well, in that it doesn't only implicate cases that are blockbuster cases like U.S. versus Texas. We all know about that case. We know about Zubik. But there are other areas of law where the 4-4 split might be problematic and surprising. Having recently been a state solicitor general, I spent a lot of time on Fourth Amendment cases. The Florida versus Jardines case is presented, which is a case involving whether or not it constitutes a search for a police officer to go up onto the porch of somebody's home and in the middle of the night with a drug dog. And the court held 5-4 that it was a search, and that 5-4 opinion was written by Justice Scalia, joined by Justice Thomas, Justice Kagan, Justice Sotomayor, and Justice Ginsburg. So this is not your classic liberal-conservative split. But Florida versus Jardines has opened a huge number of questions that are unresolved out there in the states and in the circuits about how to apply that holding to things like apartment buildings that are locked, apartment buildings that are not locked. The number of questions, and there are already split decisions out there coming out of state courts and the circuit courts. And it's not clear to me that cases like that aren't followed as closely by court watchers can be readily resolved in the current court.
Yeah, maybe just a little reminder that law happens and law evolves in this country very, very slowly, actually. So, speaking as a former Supreme Court clerk, you read through these petitions for certiorari. Again, the court gets something like 8,000 petitions and grants 80 cases, so 1%. And so if you're the clerk, it's actually almost always a safe bet to suggest deny. Like, deny is a good, safe bet, usually. And as you are writing your memo about why to deny, which, again, you write at the bottom of 99% of memos, or 98% or something, a very popular thing to write is further percolation would be useful. So, a circuit split is the best possible indicator that maybe the court will grant cert, but, circuits will split. There'll be a 2-2 split. And you'll say, well, but, maybe it'd be better if we waited to see if the 3-3 split develops, just because, another circuit court might have a useful other take on this. I mean, I'm not trying to I'm not being cynical about this. I mean, this is first of all how it works and probably how it should work. But my point is, all the time at the courts, the conversation is, let's wait another year on this and sort of see how it plays out on the ground. And that's actually the first instinct at the court as to virtually everything anyway, always. So if there are a few things on which the court says, let's wait 6 months on this, that's actually very much in keeping with the court's usual practice.
So with that, we're going to move on. Each of our panelists has a case or two that they're following with interest, and let's go the opposite way. So as Paul, we'll start with you, if that's all right.
Okay.
Paul's going to tell us about the redistricting cases, which are obviously hugely important.
They are important. These are two cases, one out of Virginia, Bethune-Hill, and one out of North Carolina, McCrory versus Harris. And they raise very common issues. They involve a pattern we started to see this last round of redistricting after the 2010 census of southern states adopting kind of across-the-board policies about the particular characteristics or population characteristics of the African-American controlled districts that they were going to draw in the new maps. One of those policies was the Alabama policy of maintaining the population of African Americans even at very high levels that existed before the census. That was reviewed by the Supreme Court and sent back with a decision that said they may very well be unconstitutional a couple years ago. The ones that were at issue here are policies not about maintaining existing African American percentages in districts, but of establishing a kind of upfront percentage that all African American districts have to meet. In Bethune-Hill, in Virginia, there's a challenge to 12 House of Delegates districts where there was an upfront policy that said all African American districts have to be at least 55% African American, even if at lower percentages the African American population would still be able to control the district and have their candidate of choice elected. In North Carolina, the policy that was adopted was 50%. And even if, as in some of these districts, they were electing the African-American candidate of choice down in the low 40s, and they raised the African-American population up in those districts to get there. The particular case in the court now from North Carolina involves their two black now majority congressional districts. And the issues in these cases, these policies were, it's not really a secret, adopted really, although they were claimed to be required by the Voting Rights Act. The interpretation of the Voting Rights Act really isn't very persuasive, and pretty clear the real reason was if you get more African Americans into these districts, the surrounding districts will be more Republican. And the attack that was brought against these districting practices were under the Shaw v. Reno doctrine, the so-called racial gerrymandering doctrine, a doctrine that says you can't allow race, even though you have to consider race to comply with the Voting Rights Act, you can't allow race to become the predominant factor in redistricting, outweighing other traditional districting principles. This was a doctrine that came about in the famous cases in the 90s involving incredibly horrendous, ugly districts that were being drawn in those days. And the argument is that if you adopt a policy up front that says it has to be 50% regardless of the particular situation of who turns out in that district, who they vote for, what level of percentage is required in order to give African Americans a fair chance to elect the candidate of choice, then you're making a rule where race is the sort of number one factor that predominates inherently. But in the Virginia case, the three-judge federal court majority said, no, that's not right. Even if you did have that kind of policy, unless you subordinated other redistricting principles and made a really ugly district, and unless those ugly characteristics can't be explained in race-neutral terms like political explanations, we're not even going to trigger strict scrutiny. So they basically blessed these districts in Virginia. The three-judge court in North Carolina took the opposite point of view and said that if you adopt such a policy, it's not justified under the Voting Rights Act. It's a number that you pick out of the air. You're raising percentages for reasons that are not justifiable under the Voting Rights Act. We're going to treat that as a violation of Shaw v. Reno, trigger strict scrutiny, and you don't have a good enough justification for this across-the-board policy. So the cases are very much in tension with each other. The court will have to decide whether or not the Shaw v. Reno doctrine can be extended into this particular context which is somewhat different from where it has been applied in the past. The states are going to argue, look, you've been suing us for years for not having enough African Americans in the districts, and now you're telling us that 50 or 55% is too much, and that we have to look at every single district and decide what the perfect Goldilocks amount is for that district that will give African Americans a candidate of choice, opportunity to elect candidate of choice without having any excess, and that's just too difficult. On the other hand, the plaintiffs are going to say this was an entire effort to achieve what amounted to partisan gerrymandering by using black voters as proxies for these political ends, and the claim that the Voting Rights Act was being vindicated by these policies is incorrect, and there's something constitutionally problematic in a very serious way about using race in that way. And so that's what the fight's going to be about. I would just note, before giving it back to you, Garrett, the idea that partisanship is okay has been around now for some years, but there are cases heading to the court in the next year or two, and watch for these, that are renewing the argument that partisan gerrymandering itself is unconstitutional. And so it may be that this fight between racial justifications and partisan justifications that we've been living with for the last decade or decade and a half will itself be a history. They'll both be unconstitutional when they get to be too excessive.
Great. So I'm going to talk about a case called Trinity Lutheran Church versus Pauley. So what happened in this case is the state had a program which involved, which involved helping playgrounds to resurface the surface of the playground. So what they were trying to do was use recycled tires to create a kind of rubber surface in the playground so that the children won't get as hurt if they fall off the monkey bars or whatever. And also have the happy side effect of fewer old tires in landfills. So it seems like a benign, nice state program. And the state has entirely neutral criteria for figuring out who gets the money to resurface their playground. You fill out a form, and we see how whether how many people use the playground and how well thought through your plan is for it and so forth. And they rank those applications, and then they give grants to resurface the playground. And so Trinity Lutheran Church applied. And they did, because they had a playground, and they have like a daycare center and also a playground, and the state ranked their application 5 out of 44, but the state wrote them a letter saying, your application's great, but we cannot give you this money because you are a church. And giving the money directly to a church would violate, apparently, or the state thought it would violate the Missouri Constitution, which says, has a sort of a Blaine Amendment-like provision, which seems to forbid direct money from the state treasury to a church. Now, that's debatable as a reading of state constitutional law, but that's what they said. And so Trinity Church is complaining that this violates the Free Exercise Clause and also the Equal Protection Clause. And this is a nice set of facts for a few different reasons. In general, we think it's not okay for states to discriminate against religion, and that's sure what this looks like. In fact, it's as clean a set of facts as you could imagine. Yes, we would give you the money, except that you're a church, but for the fact that you're a church. So that's a nice, clean example in a way. And so in general, we think states can't discriminate on the basis of religion in this way, but there's a case that seems to support Missouri here, and the case is called Locke v. Davie. In Locke v. Davie, the state was giving scholarships to students, but they refused to give a scholarship to a student who wanted to study devotional theology, that is, like trained to be a minister. And the state said, we're not providing a scholarship for that, and the court said, that's okay. The court said that's okay. And so this case, the Trinity Lutheran case, raises the question of what's the scope of that Locke v. Davey principle? When does that apply? Quite when is it okay for the state to do something like this? The broad reading of Locke v. Davey says it's okay to do this when what you're trying to do is not give money directly to a religious organization, and this or directly in furtherance of religion, and this would be giving money directly to a church. The narrower reading of Locke v. Davey is no, it's a bit of a historical exception to the rule. For deep historical reasons, we've been particularly worried about the state funding the education of church leaders. That really looks like a First Amendment problem, and so the court was particularly worried about that set of facts, and that this is quite different. This is this actually couldn't be more different. This is the funding of the playground surface. So quite how broad is Locke v. Davey is the question here. And the church says this is the easiest possible case because the thing we want to do with the money has nothing to do with religion. It's the surface of a playground. But the state says, yeah, that actually makes our case better because how can you say we're prohibiting your free exercise of religion when you can feel free to practice your religion in any way you want? It's just you have a different surface playground. So there's the clear factual distinction, but both sides think that the distinction actually favors them. So it's kind of a nice case.
So I think it is fair to say that Buck v. Davis is one of the, if not the most important civil rights case on the court's docket this upcoming term. This is a case that'll be heard on October 5th, so it's one of the early cases. And the issue is whether the Fifth Circuit erred in denying Mr. Buck's motion to reopen the judgment and obtain merits review on his claim that he had ineffective counsel, that he was denied that his counsel was constitutionally ineffective for knowingly presenting a, quote, expert, testimony from an expert, who said that the petitioner was more likely to be dangerous in the future because he is black. Now, this was incredibly important testimony because the question of whether or not one poses a future danger is a central issue when juries look at the question of whether or not to impose a death sentence. In our view, the case is a straightforward example of ineffective assistance of counsel. The underlying facts in this case, as you might imagine with any murder case, are gruesome. Mr. Buck was sentenced to death for murdering his girlfriend in front of her children, along with the murder of a man. During his sentencing hearing, his attorney, right, so not the other side, his attorney called an expert, Dr. Walter Kahano, who said that his studies had shown that black people and males in particular were more likely to be a danger to the public. And under questioning by Buck's lawyer, Mr. Kahano reviewed the findings of his report extensively. Fast forward to the sentencing hearing, and the prosecutor relied heavily on that expert's testimony in arguing to the jury that Mr. Buck should be sentenced to death and not imposed a life sentence. Now, this case is interesting. Texas has vacated the sentences of other individuals who were also sentenced to death where there was reliance on Dr. Kahano's testimony. So Dr. Kahano has been discredited. And in fact, Senator Cornyn, during his tenure as Attorney General in the state of Texas, promised that new trials would be granted in all cases involving testimony from Mr. Kahano. And that happened, except for in this one case involving Mr. Buck, which is why this case now moves to the Supreme Court. So the issue in this case is whether or not we should allow death sentences to be carried out in our country where there is evidence that the process was tainted by race. this case will be argued by the NAACP Legal Defense Fund. And I note that because I want to pivot to another very interesting point about this case. The stakes are high. I think this case is one that we all should watch. There were a diverse array of amicus briefs all urging the court to toss the death sentence in this case, views from the left, from the right, from advocates, and from others. But Christina Swarns, a really experienced and wonderful attorney at the NAACP Legal Defense Fund, will argue this case in the fall. And I think that's noteworthy for a particular reason, and that's because of the lack of diversity that we see in the bar of attorneys who argue cases before the Supreme Court today. This may mark the first African-American woman who's not a government attorney presenting argument in the well of the court in many, many years. I'll close by noting this. Linda Geffen, who was one of the prosecutors who handled Mr. Buck's case, so somebody who wanted that conviction, has said that no individual should be executed without being afforded a fair trial untainted by race. I feel very unsettled that this gravely important case will be heard by 8 justices this fall. We'll see what the outcome is, but I think it's a case that we all must watch. I'll briefly mention one other case that's on the court's docket this term. As you all know, we are still wrestling with the impact of the foreclosure crisis on our nation, and one issue that we're struggling with in many communities is this problem of zombie homes, abandoned homes, blight, erosion of the tax base in many municipalities, because we just have so many vacant properties where victims of the foreclosure crisis have left those homes and abandoned. And what is the role of banks in all of this? 2 years ago, the Supreme Court heard a case, the Inclusive Communities case, where the court confirmed by a 5-4 vote that plaintiffs could bring disparate impact claims under the Fair Housing Act. So that was a huge victory, incredibly important case that makes clear that you can bring disparate impact claims under this signature federal fair housing law. But now the court has 2 cases before it that have been consolidated, and the question is whether municipalities have standing to sue banks under the Fair Housing Act for predatory lending on the basis of race. The cases are Wells Fargo versus City of Miami and Bank of America versus City of Miami. In both cases, the district court found that the city failed to allege standing and argued that the cities fall outside the zone of interest that Congress intended to be subject to protection under the Fair Housing Act, and argued that the conduct of the banks didn't have enough of a nexus to the harm being experienced by the city. The 11th Circuit reversed, and so now this question gets pivoted to the court, but I think that this is another important case for those of us who think it's important that banks be held fully liable for the crisis that our nation experienced with the foreclosure crisis. Victims, I think, include not just individuals here, but municipalities and cities as well.
So I'm going to talk about a case that is really under the radar for lots of people. It's called Microsoft versus Baker, and I may be sinking my chances of being invited back, since I got excited about the Federal Arbitration Act before, and now I'm going to talk about Rule 23 of the Federal Rules of Civil Procedure. But I think that's really important. The issue in the underlying facts in Microsoft, about which I have absolutely no information beyond what's in the opinions and briefs and no opinion, involves Xbox users who alleged a design defect that led to damage to their game disks. And they brought a class action against Microsoft alleging, based on this product defect. So the district court denied class certification, at which point the plaintiffs felt that they couldn't proceed any further, which is often the case, and this is why the case is important. Because it's often the case when you have plaintiffs with individual but very small stakes that if class certification is denied, there's really no way that they can proceed. There used to be a doctrine called the death knell doctrine, which allowed an interlocutory appeal at that point in some circuits, but that doctrine was eliminated by the Supreme Court in a case called Coopers and Librand versus Levasseur. Instead, we now have something called Rule 23F, which is a relatively recent amendment to the rules that allows for a discretionary appeal. Plaintiffs or defendants can petition the appellate court to review a determination on class certification, but it's completely discretionary with the appellate court. What the plaintiffs here did, they tried that and they failed. So what they said is, look, we can't proceed. We might as well have judgment entered against us. And through what they called a stipulation, they had their claims voluntarily dismissed with prejudice and said, right, we're not going to come back unless we appeal and the class certification determination is overruled. So that's what's at issue here, is can they do that? Is it permissible for the plaintiffs to dismiss their individual claims and permanently to go forward, appeal the class certification determination in the hopes of getting a remand and being able to litigate for the class as a whole? I think the case is, most circuits that have addressed this have said the answer is no. The Ninth Circuit, where this case comes from, and one other circuit have said yes. I think when the case first came to the court, it was actually granted in January before Justice Scalia's death. I think I would have given the odds of the plaintiffs prevailing, made them extremely low. I think they're still pretty low. I think that the court is likely to take a relatively formalistic approach to this case and rule that you have the Rule 23F mechanism, but I'm not sure. And I think what might be most interesting about this case is, as much as the outcome, will be the tenor of the oral argument and the tenor of the opinion. Because in recent years, the court has really been extremely hostile to class actions and has found a number of different ways to make it increasingly difficult for people to bring class action lawsuits, particularly consumer class action lawsuits. And so the tenor of the argument and the tenor of the opinion may suggest whether or not there's a possibility of a shift going forward.
Well, time discipline has been kept very well, and one of the fun things about an ACS event is that we usually get some good questions, and we're going to have time for questions, but we thought that, in the spirit of sort of trying to adopt a more cable news, Sports Center format in order to retain the shrinking attention span of the public, we would go to a lightning round format before we move on. And there are cases floating around that either, are being ignored or have been decided but have implications that no one has noticed, or, may not be decided, haven't been granted yet, may not get granted but should. And so this is really up for the panelists to choose to talk for a minute or two about something that they want people to be aware of, and we'll sort of randomly scramble the order. Nick, since you're our guest, why don't you go first?
Sure, thank you. So I'll just talk briefly about one other merits case, which is Moore v. Texas. And this is a death penalty case where the claim is that the defendant is mentally retarded. So this case is of interest to me in particular because I was clerking at the court when a prior case, Atkins, was decided. Atkins is the case that held that it violates the Eighth Amendment, Cruel and Unusual Punishments Clause, to execute someone who is mentally retarded. Now, in that case, the court was a little bit vague about the definition, quite who counts, quite who is mentally retarded. And I don't think I'm telling tales out of school to say we were aware that a problem might arise with the definition. At least I will say that I was aware. And so, if you think about writing that opinion, on the one hand, you'd be tempted to say, you have to define mental retardation per the, DSM-4 or something like that. That just doesn't feel like a constitutional rule. It's kind of odd to think that the Cruel and Unusual Punishments Clause incorporates the DSM-4. And so I think there's a little hesitation to write something like that into an opinion. So instead the court said, well, the states have flexibility to figure out quite who's mentally retarded and who isn't and define their own standards. And now this case is testing that principle. So is Texas's definition of mental retardation sufficient or not? So there's a little problem that's, as it were, that was from my term that has now come home to roost. So I thought I'd mention that one.
Paul?
Well, I would just comment quickly. I think that the basic question of whether they have to be consistent with current professional standards was answered in Hall versus Florida. This is just a follow-on from that, but we'll see what they do. Two cases I'll mention quickly. One I think Carolyn mentioned before is the GG case, which is on the docket to be decided whether to grant cert this month. This is the transgender bathroom case coming out of Virginia, a Virginia high school student, where the court entered a very interesting stay order over the summer. They stayed the decision in favor of the high school student by the Fourth Circuit, which is under Title IX, the education amendments. And Justice Breyer writes an opinion saying, I'm not saying I agree there should be a stay, but I'm doing this as a matter of courtesy to the four. And so it's hard to tell where the court is on this issue. The actual merits issue in the case is not Title IX or transgender discrimination per se. It's the issue of so-called our deference to administrators' interpretations of their own regulations, which is a follow-on from the Chevron doctrine, which some of the more conservative justices have been going after in some of their recent opinions. It does seem like a cert-worthy case, in part because we have this large nationwide injunction that's been issued in this other case filed in front of a judge in Wichita Falls by a bunch of states attacking the same interpretation of Title IX that's at issue in the GG case. So that I think has heightened the stakes here. The basic the interpretation the Department of Education has adopted is that it is a form of sex discrimination if you have separate changing facilities or restrooms for male and female students, and you don't allow transgender students to use the facility consistent with their gender identity. And so that's the sort of underlying burning social issue that is it's going to be decided based on the our deference doctrine if the case does get granted. I think I'll just stop there for a minute unless I have a chance to come back to me.
Great. Carolyn, why don't you?
So I thought I'd mention a couple of cases or a couple of issues that I'm aware of from the job I had until about a month and a half ago as Illinois SG. One is a set of issues, I don't have a particular case in mind, but I think are likely to come bubbling up, and that has to do with prisoner litigation, both habeas and Section 1983 litigation. And there's already a lot of habeas litigation in the Supreme Court, as I'm sure you all know, and a lot of it involves the Supreme Court sort of slapping down circuit court judges who they think have overstepped their bounds under AEDPA, the Anti-Terrorism and Effective Death Penalty Act. But I think there's also a lot of action happening in the Section 1983 cases, in particular with respect to deliberate indifference to serious medical needs. At least that's happening in the Seventh Circuit. I can say that for sure. And the Seventh Circuit has recently not only expanded, I think, its solicitude towards prisoners in general in terms of the willingness to have claims go beyond summary judgment, but also per Judge Posner has explicitly encouraged judges to look at information outside the record in making these evaluations. So if a prisoner comes in and says, I was denied the medical care I was entitled to, and I had this serious medical need, but of course the prisoner is pro se and can't possibly hire an expert to establish that his condition in fact rose to the level of a serious medical need, the Seventh Circuit, again, there's strong disagreement on the court about this, but at least Judge Posner has said, well, look at the Mayo Clinic website. The Mayo Clinic website will tell you whether, in fact, acid reflux can be a serious medical condition. And the Seventh Circuit has also strongly encouraged the district courts to appoint counsel in a much greater array of cases. So in some constellation of these issues, I could see one of these cases making its way to the Supreme Court. More specifically, there are two cases coming out of the Seventh Circuit involving disadvantaged business enterprise programs for building highways and roads. One of these cases has already been decided. It's called Dunnett Bay. The Seventh Circuit dismissed the plaintiffs on standing grounds, and their cert petition is actually listed for next week. The other one has not yet been decided by the Seventh Circuit. It's called Midwest Fence. And if the plaintiffs are unsuccessful in that case, I would presume that they will file a cert petition. And that there are standing issues in that case, but there are also more complicated merits issues as well. So those are things to keep an eye open for.
Kristen, you get to bat cleanup in the lightning round.
So we talked about the two voting rights cases that may be taken to the court, the one out of Texas and the one out of North Carolina. But let me switch gears to a case that was just decided at the 11th Circuit, out of the 11th Circuit last week Friday. This is a case that was brought by the EEOC, and the issue was whether an employer's ban on dreadlocks constitutes unlawful discrimination on the basis of race under Title VII. And the 11th Circuit ruled that the policy did not violate Title VII. Underlying facts: African-American employee with dreadlocks interviewed for a job, did well, but was told that the dreadlocks were, quote, too messy, and asked to change or get rid of the dreadlocks. And the job applicant refused, and those facts precipitated the lawsuit. There have been many cases involved, there are a number of cases involving employers' restrictions on how one wears their hair, these kind of grooming and appearance rules that have been brought on the basis of race and brought on the basis of religion. I think the outcome of this case is deeply problematic in the world that we're living in today. Nick talked about the fact that the law sometimes evolves slowly, but I think that there is such a thing as evolving too slowly, and I think this is one area that illustrates that. So this is a case where I hope that the EEOC will keep its foot on the gas and bring the question to the Supreme Court. But then the question is whether the Supreme Court is in a position to resolve the critical issue here.
I can't resist saying, because I think the issue you flagged is terribly important, and it leads to a whole other set of issues about various cultural phenomena and can you assimilate them to race. But if there were 8 people you wouldn't pick to deal with dreadlocks, right? I'm just trying to picture the conference as like, well, why are they dread? I mean, I could see, are they scary? No, they're
Can't
not.
they just untangle them?
That's right, yes, and I would love to be a fly on that wall. That's probably not a serious point, but I couldn't resist. We have time for questions, and I hope that we will get some. If you have a question, please raise your hand. Wait for the microphone, sort of identify yourself, and because we are recording, and there's a gentleman over here.
Hey, John Vale from John Vale Law PLLC.
Yeah.
Two comments. One on Carolyn. I agree with you that Microsoft is an important case, but I think it's telling that cert was granted before Justice Scalia's passing, and I think it's telling also that we're not seeing again a number of grants on the questions of standards of proof for certification under Rule 23. I think that's an area where Justice Scalia's absence is having a profound impact on what the court has done, because they've taken cases in each of the last several years trying to address those issues and just blowing it massively with Comcast, but obviously they wanted to deal with it. Obviously now they don't. And the second is, Kristen, on the fair housing cases, I agree that those are very important, but I think that there's a broader importance in them, because one of the issues that inheres in those cases is what is the definition of proximate cause? And this is, proximate cause is an invention of late 19th century railroad lawyers, and it's being pressed again by the business community in the interpretation of everything. I think there's a recognition that it comes down fundamentally to a policy decision. But this question of how the court handles how it will decide what proximate cause means is a very important one across a broad range of statutes and across some common law claims.
Who would like to go first? You were both targets.
Well, obviously, I share your view that the timing of the grant and Microsoft is potentially quite significant. Although I'm not necessarily. I said before that I would bet that the plaintiffs will not prevail, but I was pleasantly surprised by the outcome in the Tyson Foods case earlier this year, where the court. It was sort of a class action case, and it was sort of a representative proof case involving whether or not an employer who didn't keep adequate time records could be held liable for violating the Fair Labor Standards Act on the basis of representative proof, right? Some employees statistical studies about how long it takes people to do these different tasks because they didn't have the records they are statutorily required to keep. The case was argued before Justice Scalia's death, and it was decided after his death, and it was actually 6-2 in favor of the plaintiffs in that case. So it's hard to predict how these cases will go.
Yeah, and you raise a fair point. So here, the municipalities argue that their injury, lost tax revenue, is directly traceable to the bank's unnecessary or premature foreclosure of loans. I think that these banks, should be held liable for their conduct, and that the facts should be presented to the court. And, how those facts bear out, I think, implicates how liable or the extent of the liability at the end of the day for the banks. But you are absolutely right. These are incredibly thorny questions.
Either of the other two, do you want to comment on that question? Ken, you had a question over here.
I did. I guess should be directed.
The mic.
Okay, Mike. Yes.
Ken Joe, Supreme Court Yearbook. Ms. Clark, the Pena-Rodriguez case strikes me as an important racial justice case. And let me pose the question this way. In that jury, how bad did the racist juror go in expressing his anti-Hispanic views? And in that regard, how bad does a record of such remarks have to be to invade the province of the jury? After all, this jury acquitted the defendant on the most serious charge. So how do you handicap that case?
And you might want to fill everybody in a little bit on the facts there.
Well, I invite you to do that.
Well, if Adam were here, he could recite the piece that he wrote. But in any event, this defendant, Mr. Pena Rodriguez, was accused of sexual harassment, groping, and acquitted on the main charge, but convicted on a lesser charge. And one of the jurors said, "Well, I don't believe those people, and I don't believe his alibi witness because she is all of the same ethnicity."
And this was a former police officer, right? The juror. So he kind of presented this opinion as having this credibility.
For anyone who recalls 12 Angry Men, it's Lee J. Cobb.
Yeah.
Right. Yeah. And so the question in this case is whether you pierce the veil, whether, jury secrecy is kind of a hallmark of our criminal justice system. And so do you peel back the layers to figure out whether race indeed infected the process. And I think that here on these facts, there is reason to, and it links back to the Buck v. Davis case. We should not tolerate outcomes in our criminal justice system where life and liberty are at stake when we know that race may have tainted the process. We should allow courts to really be able to, fully explore the facts here and figure out whether the outcome is an unfair and racially driven one.
It's also interesting that they're considering that issue in the wake of the Foster versus Chapman case last year, where they very strongly reaffirmed the proposition that prosecutors can't engage in intentional racial discrimination in jury selection, a rule that had been around for a while but had been disregarded. And the court, with opinion by the Chief Justice, strongly reaffirmed that rule. The question, I guess, in this case will be, are we going to treat jurors differently? Because the whole idea is to get the community in with all of its warts, so to speak, and whether this is something a whole area of litigation we're going to try to open up as a way to attack convictions after the fact.
I was just going to ask, do you think we should have retrials on the charges for which he was acquitted?
If race infected jury deliberations and the outcome, then that is not a result we should tolerate.
Interesting double jeopardy question, I would think.
Yes. And we've got a double jeopardy case this term also. Which, yeah. So somebody over here, this gentleman.
Thank you, David Sobelson, Washington, D.C. I'd like to ask Carolyn Shapiro, but really all the panel, about a recent talk I heard from Clint Bolick, who has been confirmed as a member of the Arizona Supreme Court and is calling for activity on the state constitutional level that would suggest bringing back what conservatives now call the Constitution in exile, striking down things like mandatory fair share fees, even if the Supreme Court upholds them, and presumably even state and local municipality regulations of minimum wage laws.
Well, I think that the success of that approach, I'm not familiar with the speech, but the success of that approach is going to would vary widely from state to state. I don't see it getting very far in Illinois as a matter of litigation. But we do have in Illinois a pretty pitched battle going on between our governor and the unions, and which I could go into at great length, but is not what you're here to hear me talk about. And through that, I think that the issues that Clint Bolick is talking about will continue to be pretty salient in all kinds of different states. But when I say I don't think it would be successful in Illinois, I say that both based on our Constitution, it's hard for me to imagine what the hooks would be, and also our judiciary. I don't see them being willing to be that adventurous.
I guess I'll just say this phrase, the Constitution in exile, seems to be a stand-in for the idea that there's a kind of a conservative conspiracy to reinstate Lochner or something like that. And, I guess I can just tell you that I've actually never heard this phrase at a Federalist Society event. I have only ever heard it at ACS events. So either there is no such conspiracy or I'm somehow not a part of it.
Mr. Bolick used it, then he's hardly a member of the ACS. But I would just comment that the idea of going to state constitutions and state Supreme Courts crops up on whichever side of the spectrum you're on when you see yourself losing the majority in the Supreme Court. This was clearly a response to the perception that there's a likelihood that there's going to be a liberal majority, a Democratic appointed majority for the first time in many, many years in the Supreme Court. If you went back 15 years, Justice Brennan was writing articles about how we should be doing the same thing on the progressive side of the aisle. And it's actually something you can do with some limited effects. Obviously you can't have state Supreme Courts invalidating federal law, but there are, in fact, many significant issues on which state Supreme Courts play an important role. Look at the way that the progress toward marriage equality proceeded. If it hadn't been for very important state Supreme Court decisions applying the state constitution, starting with the Goodrich case, or even before, there wouldn't have been that kind of progress. So,
Krista, did you want to say? Okay. This lady here. They're coming.
Moschenberg for NCJW, National Council of Jewish Women. Could someone talk a little bit about the two ADA-related cases that are coming up? They're not of the same ilk. One is a case from Texas, using my cheat sheet here, IVV Marath, which has to do with accommodating deaf applicants for Texas driver's license. And the other case is Fry v. Napoleon Community Schools, which has to do with the extent to which the IDA enforcement and adjudication, whatever, I'm not a lawyer, process has to be exhausted before you can call in the ADA. So I think it's important that the court took two court cases involving the ADA, and if anybody could comment on that. What it might mean, what the case is, anything.
I mean, I can talk a little bit about Fry. I'm not familiar with the other case, but Fry involved a girl who had a variety of different disabilities and wanted to bring a service dog to school that helped her. She had cerebral palsy. And this dog helped her in a variety of different ways. And the dog was new in her life, and so part of having a service dog work is that the child and the dog actually have to be together like all the time, because they have to get to know each other and understand how to work together. And the school, which had a policy that allowed guide dogs, said they wouldn't allow the service dog. And the family sued under the ADA, and the school's response was, you can't sue under the ADA, you have to exhaust your remedies under the IDEA first. So the statutory language involved in the IDEA that refers to the ADA, and in the ADA it's extremely convoluted. So just as a matter of statutory interpretation, it's sort of hard to untangle. I think that there are some very strong common sense arguments in favor of the family, of the notion that you would have to exhaust a remedy that nobody else would have to exhaust if a blind child, if the school said, we won't allow guide dogs, and a blind child said, well, that's all I need. I don't need a plan under the IDEA, an individual education plan. Would the school require that person to exhaust their remedies? That seems kind of ludicrous. I should add, Illinois filed an amicus brief on behalf of the petitioner in Fry shortly after I left. But I think it's actually a pretty significant case for the way these two questions interact with each other.
No. There's a question. The lady in the second row.
Hi, I'm Stephanie Mensmer from Mother Jones. This is really for any of the panelists, but I was wondering if you're seeing a change in the behavior of potential litigants because of the 8-member court and the prospect of a liberal majority. There was a lot of speculation, I think a couple weeks ago, when Paul Clement moved his practice to Kirkland and Ellis, and people were saying, oh, well, his gravy train of conservative causes is going to end and he's going to have to do something differently. And so I'm just wondering if there is actually a pulling back by some, maybe the conservative groups to not bring cases to the court right now, or if the corporate players are changing their strategies as well.
What do people think?
I think it's a little early to see this, because in part because people don't know what's going to happen in the election, for sure, but also because these things take time. I mean, it may well be that people have stopped bringing class action cases that the business community would have otherwise brought, but it's hard to tell yet whether that's really just a matter of timing. There was a time a year ago where it looked like there was going to be the major class action term, and there were these 3 big cases, and they all kind of fizzled out. But whether or not I would certainly expect that to happen if Clinton wins the election, and if Trump wins the election, who knows what the court will look like. So we notice we haven't touched on that at all.
There was one case that settled shortly after Justice Scalia's death, a Dow Chemical case, for something like $800 million. And Dow said they settled the case because of Justice Scalia was no longer on the court. I thought that was extraordinarily surprising that they said that out loud, but they did.
And I would just say, in short, my observation is that in the civil rights community, there's just an awareness, a mindfulness of the fact that there are 8 members at the court. But I haven't observed any major shifts in strategy or approach to the work.
There might be a year from now.
Yeah.
Yeah.
I guess without having any inside information, I'll say that I'm very skeptical that Paul Clement has gone to Crooklyn and Ellis because there are only 8 people on the Supreme Court. Yeah.
I actually sent Paul a note when this was announced, and I basically said, if you're not, not using your gravy train, could I borrow it? for a while? I think Paul is going to be fine, and this move is tremendously to his advantage. It was portrayed, I think, in some of the lawyer media as like a sign of the times. I don't think so. That would be my guess anyway. Microphone.
Given the every other day closeness of the election to come, does anybody on the panel want to discuss the likelihood of a case of Trump v. Clinton or Clinton v. Trump, and how an 8-member court would handle it?
I just don't want to live through Bush v. Gore again.
I think the odds of having the election come down to less than 1,000 votes in one state are extremely low, just as a matter of math. But there's a great deal of concern out there about disruptions of the election of one sort or another, either in the form of Mr. Trump's surveillance patrols in the Philadelphia polling places, or the Russians hacking something. I mean, and I think there's a lot of a level of concern about significant disruption of the election process that could put the result in doubt that's higher now than it's ever been in the presidential election, for a whole variety of reasons.
I guess I agree as a matter of math that it's extremely unlikely. I'd say if that were to happen, that would probably be the only thing I can imagine that would make this election worse.
Especially with a 4-4 court at the other end of the. We would probably make it all the way to the House of Representatives this time. I think that's the likely.
But it is fascinating to just reflect on how much the world has changed since 2000, how much our election system has evolved. There's still breaks and a tremendous amount of work that we need to do to make sure that everyone can participate. But hanging chads, no longer a term in our vocabulary. Since we are just hypothetically speaking here, I can imagine such a battle being focused on provisional ballots and how they got counted jurisdiction by jurisdiction, and was there uniformity and true compliance with the Help America Vote Act and other state rules that apply. So your question, is striking in that, voting and elections really, really has evolved and changed a great deal in the last 16 years.
Did you? Well, I just want to say on that point that I, as someone who has a dog in the fight, and I'll let you guess which candidate I observed a number of things that have happened since the advent of the 4-4 court with some interest and thought about how is this going to affect the valence inside the court if we do get highly partisan questions coming out of the election. And it strikes me that it is now very different, and even for the conservatives on the court, must seem very different to have a relationship to the Republican Party than it did in 2000. And I remember when Chairman Grassley in particular really decided to let us all know what he thought about the Chief Justice. I was just like, yeah, go for it, man. Just call the Chief Justice every name you can think of, because you may need him in a few months, And so I wonder whether, I just wonder what is going on in the minds of some of these conservative justices when they look at what the Republican Party is today, because it's not the party that produced them. And whether that will have any effect on the court's work, I can't imagine. But it underlines what strange times I think we live in. Have we got, we have time for probably one more?
Oh, hello. I'm wondering what are the potential ramifications should Judge Garland be confirmed into the Supreme Court sometime later? effect would it have?
Well, Judge Garland has a stellar reputation as an incredibly careful, thoughtful judge, and he's known really as a judicial moderate. I don't think anybody expects that he will be the next Justice Brennan or Justice Marshall. And there are lots of areas where he hasn't ruled in lots of areas because of the nature of the docket and the D.C. Circuit. So, I mean, I guess of the justices who are currently on the court, this is a terribly presumptuous thing to say because I don't know Judge Garland, but it seems to me that his approach might be most similar to Justice Breyer's, but it's very, very hard to say.
So whenever there's a vacancy on the Supreme Court, the Lawyers Committee for Civil Rights Under Law undertakes a very careful review of the nominee's record, and we did that with Judge Garland. There's a report outside the room on the table that you can feel free to take when you leave, but we looked at all of the civil rights rulings issued by Judge Garland during his tenure on the D.C. Circuit. And what we found was very interesting. There were not a lot of civil rights cases, as Carolyn notes, and I think that is because the D.C. Circuit is such a unique court with specialized jurisdiction over many cases. Many of his cases are unanimous, which shows that he is somebody who knows how to, broker deals and build consensus. His rulings have been very, very fact-driven, so they don't tend to have a lot of precedential value. They really tend to be kind of sharply focused in on the facts in the case before him. And among the kind of universe of civil rights cases, we found the most, the greatest volume of cases to be in the employment context, and that's an area where he tends to really stand for cases, being heard on the merits and favors bouncing cases back to the lower court so that litigants get their day in court, and he tends not to bounce cases on procedural rules. So all that to say that I think that he is a nominee worthy of consideration, and we remain hopeful that he'll get his day in court. He will get a hearing and a vote before Congress. If that happens, it's interesting to think that he would only be able to hear about half the cases currently on the court's docket this term. So I think this is a good note to end on, that, it is important for Congress to do the work that it needs to do to fill that vacancy that's lingered for just too long on our nation's highest court.
Nick, you?
I think I won't comment on what kind of a justice I think Justice Garland would be, but I will say that I know him very slightly personally, and he's an extremely nice man and very gracious, and I quite admire him. So I'm not going to say anything bad about him here.
Paul?
I agree with everything Kristen said about him in terms of his sort of moderate nature and personality and deference to other branches and all. He clearly, however, is a very different justice than Justice Scalia, and there are any number of cases in the last 15 years or 20 years you can think of which he would have voted with the Liberal bloc. And so there will be a significant change of direction if that happens.
Well, with that prospect, why don't we conclude, and please thank our panelists.